We're live. All right, we're back in Senate Judiciary. It is 21st. We are taking up Prop 4, and we have Julio Compton from the Attorney General's office. And the floor is yours. Thanks for being here.
Thank you for inviting me. And just for the record, again, my name is Julio Thompson. I'm an assistant attorney general and co-director of the Attorney General Civil Rights Unit. The Civil Rights Unit in the AG's office has a few core functions. One of those is to enforce Vermont's fair employment practice laws, which would be Vermont's equivalent of Title VII, the Age Discrimination and Employment Act, and the ADA, all kind of rolled up together, as well as Equal Pay Act. We also enforce civil side Vermont's hate crime laws. We obviously appear here in the legislature from time to time. I teach the hate crimes course at Vermont Police Academy since 2009, so pretty much any officers that are on the road have gone through the training that we've designed. And we also have a portion of our portfolio, at least in the last year, it's been more concentrated in the last year than in the several years prior to that, is that we have a small slice of some of the federal litigation that we have ongoing against the federal government. I think my approximate count of the number of lawsuits that we have against the Trump administration right now, where we're a direct party, is about 40, maybe a little over 40. The Civil Rights Unit owns a small piece of that litigation portfolio. So we are, for example, in the birthright citizenship case, as well as a number of other cases where we successfully untethered state funding, such as transportation funding or FEMA funds, from demands from the federal government that we cooperate and participate in immigration enforcement. We've been thus far successful in those efforts. And that relates, I think, a little bit to some dimensions of proposal 4 that I'd like to talk about briefly. So as a practical matter, day to day, our operations on the fair employment practices side won't really change. Vermont has long enshrined in statute very similar protections that are identified here in Prop 4. But it's important that to note several additional dimensions of kind of legal support for these principles that Prop 4 would bring. One is that in the future, when new legislation is proposed, it's common exercise for our office, and I think legislative council, to always evaluate a new bill in light of what the constitutional standards are. And so if the legislature enacts Prop 4 the second time and the voters ratify it, then we will have much more specific and detailed yardstick by which to compare legislation about its effect when it comes to equal protection for Vermonters. That's something that is sort of done in a rough approximate way, but maybe under the common benefits clause. But this is a much more detailed instrument by which we would evaluate and propose, like, what is the impact of this bill or this proposed amendment to law, maybe to existing law? How does it square with the core language of Prop 4, which would add this? Another way I think it would change our practice, at least in the near term, would be, again, assuming that it's ratified by the voters, would be that when we go into federal court and we are asserting what Vermont's own interests are in a particular issue, I think it adds a little bit of weight. It's hard to put a number on it. You couldn't really quantify it. But whenever we're involved in this litigation, it's incumbent upon us as representatives of the state of Vermont to articulate to a federal court, whether that be a district court or indeed the U.S. Supreme Court, what Vermont's stake is in that particular issue. And when we can direct courts to our Constitution as opposed to statutes, I think that adds a greater weight. We've seen that litigation with other states where they point to their constitutional provisions, and I think that gives a little bit of extra deference.
Yeah. In that topic, can you share a bit more information about jurisdiction of the U.S. Supreme Court? And I mean, it's my understanding the U.S. Supreme Court has discretion to hear all cases that come from a state Supreme Court. Decisions from the state Supreme Court can be appealed to the U.S. Supreme Court, that's my understanding. And so does this in any way somehow change any of that, or do the same US constitutional standards apply?
Well, the Supreme Court has authority under Article 3 of the Constitution to decide federal questions or questions that are either presented to it or expressly in the Constitution or through federal laws that govern federal judiciary. So it is not the case for, there are certain things that are purely a matter of state law where that could not be appealed to the US Supreme Court. I mean, one can always petition to the Supreme Court, but the Supreme Court would invariably not grant review. For example, if you had a case involving the appeal of a burglary conviction under state law, and the argument is that there were inadequate jury instructions. If there were no legal claim that presented something like a federal Fourth Amendment violation or a federal Fifth Amendment violation, a violation of the right against discrimination, the Supreme Court would not have authority under Article 3 to review a matter purely of state law. Where the Supreme Court, I think, the US Supreme Court, I think, would have occasion to look at Prop 4 or Article 23 would be in evaluating, again, a state's interest as it may bump up against a federal statute or as it may bump up against a provision of the federal Constitution. But if there were just a question presented purely of Vermont law, like what does a provision of this Vermont statute mean, where there is no federal right that's at issue, the Supreme Court would not be evaluating that. So in all instances, Supreme Court, like they may look, for example, and compare how these provisions stand up against the Supreme Court precedent regarding the Equal Protection Clause under the 14th Amendment. But you have to have that federal tie for the Supreme Court even to be willing to consider or able to review it. And under the Supremacy Clause, you've probably heard in different contexts, the state constitution cannot cross lines that have been drawn by the federal constitution. But that doesn't prevent states from offering greater protections within what federal law allows.
I think you kind of answered my question just now, but I'm curious, and the answer may be that they can't, how it would happen where a Vermont constitutional change that is more protective would ever come under the scrutiny of the US Supreme Court.
Well, it could be, for example, that it could be that there's let's say there is a government decision, a statute that's enacted that may be arguably consistent with the language of the Vermont Constitution. If there were an allegation that it is inconsistent with Supreme Court precedent on the 14th Amendment or the First Amendment. And it's hard to imagine with those cases what might be areas where it might come up is where you deal with laws that explicitly address protected categories such as race, sex, gender, or natural origin, or religion. Those tend to be areas of a lot of case law. And so the question would be, merely being able to pass muster under Vermont's constitution wouldn't be enough. If something arguably violates the federal constitution, then it would still be valid.
I guess I'm still having, in relation to Prop 4, I could see how it might be challenged at the federal Supreme Court level if we were excluding race, gender, things that are explicitly protected under the US Constitution. But given that we are simply adding to that list, I'm just having a tough time wrapping my head around how it could be challenged because it's simply more protective.
Well, I mean, to use a cat, so for every protected category, everybody belongs to a multiplicity of, we all have a race, for example, we all have a national origin, we all have a sex and a gender identity. And so if there were a law, for example, if the legislature were to enact a law that specifically, conferred benefits to one race that were over another race, and if the argument were that, well, that's contemplated by the Vermont Constitution, someone could challenge that without even addressing the Vermont Constitution, may be able to go to federal court and say, well, regardless of what Vermont law says, federal law says you can't have racial preferences unless you have a compelling interest in no other way to accomplish your objective. And so they can challenge it fairly under federal law. So Vermont's Constitution doesn't supplant the law. And so when you say protection, sometimes, again, it's an anti-discrimination principle. So if you're favoring members of one protected category over another, that's how people can at least make the argument that they're aggrieved by that government action.
But that would be a theoretical future statute, not this change to the Constitution, correct?
I don't think there's anything in Prop 4 that itself would result in
Okay.
a federal constitutional challenge.
Thank you.
No, I don't.
Thank you. Sorry, I kind of ended up disrupting your train of thought. Did you have more testimony after my initial questions? Sorry.
Yeah, just a couple of things. One, it's my habit sometimes to dive into the nitty gritty. I mean, I should have started by saying, of course, our office supports Prop 4. I started by, exploring some of the benefits of it. That's why we support it. We don't think it's particularly controversial, but I think it is important to have this in the law where there is greater clarity than what we've had about what if Vermont accepts it, about what Vermont stands for and what they expect of their public officers. I and all of my colleagues, for example, take an oath to uphold the Vermont Constitution. And if Prop 4 is enacted, we're taking an oath to uphold this new provision as well. And we have greater clarity on what our obligations are. And I think there's a benefit to public officers knowing with greater clarity what those fundamental rights are, so that it can guide our actions, so we can be, we can follow those guardrails, more precisely and be and more judicious in how we exercise state power. I have nothing else to add.
Committee, any questions, comments, or thoughts for Julia? Well, thank you very much, Mr. Chairman. Thank you.
When I read that agenda, I saw the name at the top of it, so I apologize.
Oh, no worries. It's a living document.
So that was my bad.
Oh, no worries. All good. Thanks for your flexibility. Yeah, so please introduce yourself and floor is yours.
Which I want to thank Henry for all the work he supported me and also support us out here. So thanks a lot, Henry, for coordinating this. Good morning, Chair, members, and Senate Judiciary Committee for Constitutional Record. My name is Reverend Mark Hughes. I served as the Executive Director of the Vermont Foundation of Justice Alliance, and I've worked for many years with communities and state partners addressing civil rights, systemic racism, as well as democratic integrity. I'm here before you today in strong support of Proposal 4, the Equal Protection Amendment to the Vermont Constitution. I want to begin by stating something plainly for the record. The warnings that we brought here were correct. What we anticipated constitutionally, legally, and morally is now materialized. And what I want to acknowledge the gravity of this moment. This committee is operating at the intersection of constitutional amendment, civil rights collapse at the federal level, and long-term judicial stewardship of the state of Vermont. History will look back on moments like this, not by what was debated, but by what was secured. So almost 3 years ago, we undertook this effort to advance Equal Protection Amendment because we were following the trajectory of Vermont's own work in watching the direction of the federal constitutional law. That trajectory included Act 54, which was the RDAP, Racial Disparities in the Criminal and Juvenile Justice System Advisory Panel. Act 9, which created the Office of Racial Equity. Executive Order 4-18, which did the same. It still exists for the record. Proposal 2 in 2019, the constitutional amendment to abolish slavery. Act 33, the Health Equity Advisory Commission, and the joint legislative resolution R113, racism being declared as a public health emergency, as well as Act 182, the Land Access Opportunity Board. In November 2022, 88% of Vermonters approved the amendment abolishing slavery. Vermonters demonstrated a shared understanding that truth is the foundation of justice. At the same time, we warned that statutory progress without constitutional grounding would not survive. It would not survive a hostile turn in federal doctrine. That warning has been validated. So we're no longer talking about erosion. We're witnessing systemic dismantling. Over the past 2 years, the federal government has neutralized the Department of Justice Civil Rights Division, including police oversight, weakened and sidelined the EEOC and the OFCCP, effectively dismantled HUD fair housing enforcement, crippled Title VI enforcement through the Department of Education, closed and defunded EPA environmental justice offices, abandoned USDA programs designed to remedy documented discrimination, and actively chilled civil rights education, DEI, and remedial policy nationwide. At the same time, the Supreme Court has ended affirmative action, weakened voting rights enforcement, overturned settled precedent, and reframed equal protection as an abstract race neutral divorced from historical harm. Let me be clear. The federal civil rights posture today is among the most hostile to remedial quality that this country has seen since the 19th century. This moment bears an unavoidable comparison to the 1880s, the period following Reconstruction. Then constitutional amendments existed on paper. Federal enforcement collapsed, courts narrowed doctrine, states were left exposed, racial hierarchy was restored through law, policy, and indifference. Decisions such as the Slaughterhouse decision, the civil rights cases, and Plessy versus Ferguson hollowed the 14th Amendment for nearly a century. What we're witnessing today is not identical, but is structurally analogous. The quality is again being treated as symbolic rather than enforceable. Disparate harm is again deemed constitutionally irrelevant. History teaches us this lesson clearly. When equal protection collapses, democracy collapses with it. Federal equal protection doctrine is not equipped to address modern discrimination. Under current jurisprudence, intent is required. Disparate impact is discounted. A rational basis review dominates. Strict scrutiny is weaponized against remedial policy, and structural and algorithmic discrimination remains largely invisible. Systemic racism operates through facially neutral systems: housing, finance, employment, screening, zoning, policing tools, education pipelines. When courts refuse to see impact, they legitimate inequality. This is how equal protection becomes hollowed out while remaining formally intact. Despite these realities, Vermont has no equal protection clause in its constitution. Article 7, the Common Benefits Clause, was never intended to serve that function. As Professor Teachout testified before this committee, it addresses special privileges, not classification based upon discrimination. Article 7, using Article 7 to do equal protection work is using the wrong tool for the task. Approximately 22 states have explicit equal protection provisions. Vermont does not. In the current federal environment, that absence is no longer academic. It's dangerous.
In periods when the federal civil rights enforcement collapses, state courts become the last line of constitutional defense. History shows that when courts become aligned with or deferential to hostile doctrines, the consequences are profound and long-lasting. Civil rights statutes are narrowed and invalidated. Desperate harm becomes normalized. Vulnerable communities lose protection, and democratic legitimacy erodes. At moments like this, judicial independence, constitutional clarity, and moral courage are not abstract ideas. They are safeguards against catastrophe. The integrity of Vermont's highest court matters most when equal protection is under threat, not when it's secure. Proposal 4 provides Vermont with a state constitutional foundation for equal protection, independence from federal doctrinal collapse, capacity to address disparate impact and systemic harm, authority to scrutinize discriminatory algorithms, constitutional support for durable civil rights policy. It does not mandate outcomes. It does not override federal law. It does not eliminate judicial review. It provides authority and clarity precisely when it's needed most. Courts interpret constitutions through text, not intent. Vermont has repeatedly declared through statute, executive order, resolution, and constitutional action that eradicating systemic racism is a compelling state interest. I want to state this clearly for the constitutional record. Proposal 4 is intended to give constitutional effect to Vermont's determination that eradicating systemic racism is a compelling state interest and to ensure that state action may be evaluated based on both purpose and effect. As a Christian minister, I must say this. Our moral traditions teach us to care for the poor, to defend the oppressed, and to set the captives free. They teach us that silence in the face of injustice is not neutrality. It is complicity. This is not about Republican. It's not about Democrat. It's not red. It's not blue. It's not left. It's not right. This is about right and wrong. And these are not ordinary times. Now is not the time for silence. Now is the time to stand up and speak out for justice. In closing, equal protection is not special treatment. It's the condition under which the law is legitimate and democracy endures. After Reconstruction, this nation failed to act, and we paid a terrible price for it. Proposal 4 is Vermont's opportunity to choose differently. I urge the committee to advance PR4 to ensure equal protection in Vermont is not symbolic, not contingent, and not left to chance. Thank you for your careful attention. I'm prepared to answer questions.
Thank you. Committee, any questions or comments? Thank you. Appreciate it.
Thanks.
That's Gary Brown. Good morning. Good to see you again. Yeah, whenever you're ready, just please state your name for the record and where you're from or who you represent, and then the floor is yours.
Sure. I'm Sherry Brown. I'm the executive director of the Vermont Commission on Women. We are an independent state agency working to advance rights and opportunities for women and girls in Vermont. We've been doing this since 1964. And our work is guided by a collection of policy statements that are adopted by the full commission, and they've actually been updated. And the policy statement that guides my testimony today is one that was first adopted in 1995. And while some of the details probably need to be updated, its essence, it brings to today was been over 30 years ago. That's really what the commission passed at that point. Whereas the Vermont Constitution states that all persons are born equally free and independent and have certain natural, inherent, unalienable rights, amongst which are the enjoying and defending life and liberty, acquiring, possessing, and protecting property, and pursuing and attaining happiness and safety. And whereas, although the Vermont Constitution guarantees full rights for all persons, the reality is that this guarantee is neither recognized nor practiced by our society as a whole. And whereas in Vermont, as well as the rest of the nation, a great deal of work needs to occur in order to ensure every citizen's full civil rights is guaranteed under the Constitution. Now, therefore, be it resolved that the Vermont Commission on Women supports legislation, policy programs, and initiatives that facilitate full civil rights for all people, regardless of race, color, religion, national origin, gender, sexual orientation, gender identity, ancestry, place of birth, age, disability, or mental disability. We apparently tried really hard to make every single thing on there as you are working to do this amendment. So VCW has been engaged in efforts to adopt an equal rights amendment at both the federal and state levels throughout our over 60-year history. But in fact, we came to this fight relatively late, historically speaking. Proposal 4 that you're considering now is built on the foundation of hundreds of years of efforts on the part of generations of American women to secure equal legal rights. In 1986, decades after this first started and nationally, a proposed amendment to the Vermont Constitution that addressed protection on the basis of sex failed at the ballot. Some of the arguments heard at the time included the fear of legal and social consequences, such as reproductive rights and gay rights. In Vermont, we heard testimony about threats that passage of the ERA would lead to the interpretation of sex as inclusive of sexual orientation, leading to same-sex marriage and other protections of gay rights. Testimony at the time warned that we would be forced to hire homosexuals as teachers or allow women to serve as counselors, which sounds a little quaint now, right? Something
That's the word I've used.
yeah. and so in the decade since, this was 40 years ago, is that right? 1986. Vermonters have recognized that these other protections that we were warned against are in fact protections that are just as necessary as those against sex discrimination. We have a broader understanding of equity now, as well as of the interconnectedness of forms of discrimination. Through our laws, we have recognized many of these rights, but of course, laws can change. This is why Vermont amended our Constitution to include the right to personal reproductive liberty and to abolish slavery, and why the Vermont Commission on Women supports Proposal 4, which would explicitly prohibit the state of Vermont from engaging in discrimination and unequal treatment on the basis of sex, sexual orientation, gender identity, and gender expression, among other important protected classes. We believe it is long past time for Vermont to take this important step at providing additional constitutional protection for all our residents. We are living in a time when we can no longer take for granted that the legal and social gains made for equality based on sex or any other class will stand. We've never been able to take for granted that the courts will interpret the Constitution's current wording to protect people based on sex or any other class. And while we cannot predict how the Vermont Supreme Court will decide to analyze cases under this proposed amendment, we do hope and anticipate that it will trigger a heightened standard of review by the court in accessing government actions that treat people differently based on their membership in a protected class. Today in public discourse, we hear echoes of the sentiment that defeated the Equal Rights Amendment back in 1986 in Vermont. At the time, Vermonters were told that constitutional protection would undermine traditional gender roles and destroy the very heart and structure of the family. They were told that equality in the Constitution would erode the natural roles and norms of men as providers and women as caregivers. And on a personal note, I can tell you that when I was a child growing up in the 1970s, my mother hosted women's living meetings in our living room, and I never, ever would have dreamed that my children would grow up to hear the Vice President of the United States tell women that working full-time instead of having children is a path to misery. Or to say, we actually think God made male and female for a purpose, and we're going to help with our public policy. We see that through. We support and appreciate the move to create a standalone equal rights amendment in Article 23 of the Vermont Constitution, as well as the inclusion of the language. Nothing in this article shall be interpreted or applied to prevent the adoption or implementation of measures intended to provide equality of treatment and opportunity for members of groups that historically been subject to discrimination. We believe that taken as a whole, the This equal rights amendment will send a bold and timely message about our values and will also monitor support and protection from discriminatory selection. Thank you.
Committee, any questions or comments? Okay, not seeing it. Thank you very much. So we can break until 11:30. Is there any chance we can see if Michelle can come in 11:15? Thanks.